Late last night, while most of Washington had already shut down for the day, something unexpected landed inside the court system. It wasn't announced. There was no press conference, no public warning, just a filing, quietly submitted, but immediately noticed by the people who matter most. This was not a routine document. Court filings usually follow predictable patterns. They arrive during business hours. They fit into established schedules. Judges and clerks expect them. This one didn't follow that rhythm, and when something breaks pattern inside the legal system, it triggers attention before anyone even reads the first page. Within minutes, internal alerts began moving. Clerks flagged the submission. Schedules were reopened. What had looked settled earlier in the day suddenly wasn't settled anymore. That's how fast momentum can shift when timing alone changes the equation. The filing came from the legal team representing Donald Trump, and its timing was the first signal that this move was deliberate. Late-night filings aren't about drama. They're about forcing the system to react on unfamiliar footing. Judges don't like surprises, especially procedural ones. When a filing arrives outside the expected window, the court has to answer questions immediately. Does this affect existing deadlines? Does it require acknowledgement before other actions proceed? Does it introduce issues that can't be ignored without creating risk later? Those questions don't wait until morning. Inside the court, the process is quiet but intense. Clerks review structure before substance, jurisdiction before argument, authority before claims. The goal isn't to agree or disagree. The goal is to determine what obligations now exist simply because the document is there. That's where the scramble begins. This filing didn't argue loudly. It didn't posture for cameras. Instead, it pressed on timing, procedure, and rights that courts are legally required to consider once raised. That alone can freeze parts of a case until clarity is restored. Legal observers quickly noticed that the move wasn't designed to win headlines. It was designed to force acknowledgement, and acknowledgement changes everything. Once the court acknowledges a filing, it must decide how to deal with it. Ignore it improperly, and the record becomes vulnerable. Address it too quickly, and mistakes happen. Delay too long, and pressure builds from all sides. There's no comfortable option. Opposing parties now face a problem of their own. Even without a public order, they must prepare responses. Teams are pulled back in. Drafts are reopened. Strategies are reassessed under tighter timelines than expected just hours earlier. This is where late-night filings quietly create leverage, not because of what they say, but because of what they force others to do. Every adjustment increases risk. Every rushed decision creates exposure. Courts are aware of this, which is why reactions are measured, not emotional. But measured doesn't mean passive. Behind closed doors, judges are already considering how this filing fits into the larger structure of the case, not whether it's persuasive, but whether it alters the procedural path forward. That distinction is critical and often misunderstood by the public. Courts think in pause, not moments. If a path changes, even slightly, outcomes months from now can look very different than they did the day before. That's why experienced legal analysts are paying close attention to what the court does next, not what it says. So far, the silence is intentional. No immediate rulings, no public statements, just internal recalibration. That's often a sign that a court is being careful, not caught off guard. But careful doesn't mean unaffected. This filing has already done something important. It has slowed certainty. It has introduced questions where there were answers earlier. And in legal battles, uncertainty is power. What happens next won't come with alarms or dramatic language. It will come through procedural moves that look small but carry weight. A revised schedule, a delayed action, a narrowly worded order. Those details decide cases long before verdicts do. And this is only the first phase. Because what most people don't realize is that filings like this don't just affect the present moment. They shape the record. They frame how future decisions are reviewed. They influence how higher courts may later view what happened here. That's why the reaction inside the legal world is controlled but intense. And why this late-night move has already changed the temperature of the case. As the night moved forward, the filing continued to circulate quietly inside the system. Not publicly, not politically, but procedurally. That's where real legal pressure forms. Long before cameras turn on, courts begin deciding what they are now required to do. This is the part most people never see. Judges don't react to filings the way social media does. There's no instant judgment, no emotional response. Instead, there's a methodical review of consequences. If this filing exists, what obligations now exist with it? That's the question guiding every internal discussion. Timing is central here. Late filings compress space. They narrow windows. They reduce flexibility. Even when courts want to move cautiously, compressed time forces prioritization. And prioritization changes outcomes. One procedural question immediately rises above the rest. Does this filing affect anything already in motion? If the answer was even possibly yes, the court must pause. Not to agree, but to protect the integrity of the process. That pause alone can shift momentum. Inside the courthouse, clerks begin drafting internal summaries. These aren't opinions, they're maps. They show judges where this filing touches existing orders, deadlines, or pending decisions. If those intersections exist, the court cannot simply move forward as if nothing happened. This is why legal observers say the filing forces review rather than demands victory. Another quiet effect begins spreading outward. Opposing legal teams now face uncertainty. They don't yet know how the court will respond, but they know they must be ready. Drafts are reopened. Arguments are stress-tested. Emergency contingencies are discussed. Preparedness becomes urgency. This isn't panic. It's calculation under pressure. Courts are especially careful in high-profile cases because every procedural decision becomes part of the permanent record. Even silence becomes meaningful later. Judges know future reviewers may ask why something was or wasn't addressed at this stage. That awareness slows everything down even as pressure builds. What makes this filing particularly effective is that it doesn't force an immediate ruling. It forces a decision about process, and process decisions are harder to justify away on appeal. They must be clean, careful, and well documented. This is where judges begin thinking defensively. Not defensively in a political sense, but institutionally. The goal becomes protecting the court from claims of oversight, exclusion, or imbalance. Every step must be traceable. Every response must be justified. That's why courts often respond indirectly at first. Instead of addressing arguments, they address schedules. Instead of ruling on substance, they rule on procedure. These moves may look small, but they define what can happen next and what cannot. Another factor quietly at play is sequencing. Courts operate on sequence. Which issue is addressed first can determine which issues are even reachable later. A well-timed filing can move an issue earlier in the sequence, changing the order in which questions are answered. And order matters. If one question is resolved first, others may become irrelevant, or stronger, or weaker. This is why timing alone can act as leverage without a single argument being accepted. Right now, judges are deciding where this filing fits in that sequence. That decision won't be announced loudly. It may appear as a simple procedural note or a short order, but behind that order will be hours of internal review and cautious debate. Publicly, nothing seems to be happening. Privately, the case has entered a new phase. Legal professionals watching closely aren't waiting for dramatic rulings. They're watching for subtle signals. A rescheduled date, a revised briefing order, a request for clarification. Those are the tells. They indicate the court is engaging, and engagement means the filing has already done its job. What comes next depends on how far the court believes it must go to address the filing responsibly. That range is still open, and as long as it remains open, uncertainty remains. Uncertainty is uncomfortable for everyone involved, but in the legal world, uncertainty is often where leverage lies. As the process continues, one thing becomes clear to everyone watching closely. Courts rarely announce when a filing has changed their approach. They signal it indirectly, and those signals are already beginning to appear. When judges choose not to respond immediately, it's often because they are deciding how to respond without creating unnecessary exposure. Silence at this stage isn't hesitation. It's control. Courts protect themselves by moving carefully, especially when timing has been disrupted. This is where many high-profile cases quietly pivot. Instead of issuing a direct ruling, courts may adjust the environment around the case. Schedules shift. Internal priorities change. Other matters slow down. The case doesn't stop, but it doesn't move the way it did before either. That shift alone tells experienced legal observers that the filing is being taken seriously. Another reason courts move cautiously here is precedent. Every procedural choice sets an example. Judges are aware that similar filings in future cases could point back to what happens now. That awareness adds weight to even small decisions. It also explains why language becomes more precise. When an order finally appears, it may be short. It may sound neutral, but every word will have been tested, not just for meaning, but for how it might be interpreted later by higher courts or opposing counsel. This is how institutions protect themselves. Opposing teams are now operating in a waiting posture. They cannot move forward aggressively without risking missteps, but they also cannot remain passive. Preparation continues behind the scenes, even as public silence holds. This balance is exhausting, and courts know it. Fatigue can influence errors. Pressure can rush judgment. That's why judges often slow the pace intentionally, forcing all sides to operate on the court's terms rather than their own. This filing has effectively shifted control back to the bench. That doesn't mean outcomes are decided. It means the court is now actively managing the path forward, rather than allowing momentum to dictate it. And that distinction matters more than most people realize. Legal history shows that cases often turn not on dramatic rulings, but on quiet procedural moments like this. Moments when the court chooses structure over speed, order over urgency. From the outside, it looks uneventful. Inside, it's anything but. Every document filed from this point forward will be read in the context of what happened here. Every argument will be measured against a recalibrated process. Every delay or acceleration will carry additional meaning. This is how cases evolve. The filing has already done what it was meant to do. It introduced uncertainty where certainty existed. It forced review where assumptions had settled. And it reminded every participant that timing is not neutral in the legal system. It's strategic. What happens next may arrive quietly. A procedural order, a calendar adjustment, a request for clarification. These moments won't trend instantly, but they will shape everything that follows. And when the next visible move finally comes, it will trace back to this late-night filing. Because in the legal world, the most important moves are often the ones made without noise. And this one is still echoing.